Let us now discuss the powers of the central government. The central government may appoint persons having expertise in the field of investigations, cyber forensics, they may be persons from financial accounting, management accounting, cost accounting, and any other field as may be necessary for the efficient discharge of SFIO functions under the Act. Rule 3 of the Companies Act, Inspection, Investigation and Inquiry Rules 2014 provides for it. The central government, where it deems appropriate, may assign the investigation into the affairs of any erring company as per the provisions of Section 212 to the SFIO. Further, if the central government so directs, the SFIO shall submit an interim report or investigation report on completion of the investigation to the central government. On receipt of the investigation report, the central government may, after examination of the report and after taking such legal advice as it may think fit, direct SIFO to initiate prosecution against the company and its officer or employees who or have been in employment of the company or any other person directly or indirectly connected with the affairs of the company. Where the central government orders such investigation, it may require the applicant to give such security not exceeding rupees 25,000 for payment of costs and expenses of investigation as per the criteria which has been mentioned in the Rule 5 of the Companies Inspection Investigation Rules, as I just talked 2014 rules. Now talk about investigation by the tribunal, and Section 213 of the New Companies Act provide for it, and it says that the following other cases the tribunal may order investigation into company's affair where an application has been made by a member, not less than 100 members or members holding 1/10 of the total voting power in the case of a company having share capital not less than 1/5 of the person on the company's register of members in the case of a company if the company is without share capital. And the said application should be supported by such evidence as may be necessary for the purpose of showing that the applicants have a good reason for seeking an order. And if that application is made by any other person or otherwise if the circumstances suggest that the business of the company is being conducted with intent to defraud its creditors, members or any other person or otherwise for fraudulent or unlawful purposes or in a manner oppressive to any of its members, or that the company was formed for any fraudulent or unlawful purpose. Persons concerned in the formation of the company or management of the affairs have been guilty of fraud, misfeasance and other misconduct towards the company or towards any of its members, or the members of the company have not been given all the information about its affairs which they might reasonably expect, including information relating to calculation of the commission payable to managing or other directors or to the manager of the company. Reasonable opportunity of being heard must be provided to the concerned parties. The central government shall appoint one or more persons or inspectors to investigate into the affairs of the company. Such inspectors shall submit their report to the government. The defaulting persons are liable to be punished for fraud, and that has been provided under Section 447. Let us talk about investigation of ownership of the company. Sometimes what happens in public interest, it becomes necessary for the central government to know the true persons who are financially interested in the success or failure of a company and control its policy or materially influence the policy. So, in view of these mentioned reasons, Section 216 of the Act provides that the central government shall appoint one or more inspectors to investigate and submit report on matters pertaining to the company and its memberships. Moreover, the central government is bound to appoint inspectors if the tribunal in the course of any proceeding before it directs that the affairs of the company ought to be investigated as regards its memberships and other purposes. The central government may define the scope of the investigation, whether in respect to the matters or the period which it should extend, and particularly may limit the investigation to matters connected with particular shares or debentures. The powers of inspectors shall extend to the investigation of any circumstances suggesting the existence of any arrangement or understanding which, though not legally binding, may be observed, may be in present or past, or is likely to be observed in future or in practice, and which is relevant for the purpose of investigation.